Welcome to this video for writtenlegalenglish.com, where we go over the questions that I posed you last week as regards the use of provided that in legal texts, and I'll quickly go through them, give you some pointers, give you some hints, and then wrap up the last 3 weeks where we've looked at 3 terms which we should not use in your written legal English. Explaining why we shouldn't use provided that is a little bit more of a harder sell than when I'm explaining why you shouldn't use shall or and or. And that's because, generally speaking, provided that means if. And it does. But provided that also means 2 other things. It can also mean except when, in other words, creating an exception of some kind, and it could also mean and. Now, provided that means if, in my experience, around about 70% of the time. It means except when, or providing an exception, around about 25% of the time, and in very rare cases, it means and. But the issue is that the courts have decided that provided that can mean those 3 things. So, if you have a look at provided that, those 3 interpretations are equally valid interpretations. Now, the 2 texts that I gave you to look at last week rather prove this point. The first text, if you have a look at my answers, my corrections, and remember they are only my suggestions and without wider context, then of course other possible answers might be okay, and indeed you might have even come up with different possible answers. But my answers, if you click on the link below if you're watching this on YouTube, or above if you're watching this on Facebook, it'll take you to the Google Docs page where I go through my answers and explain why I've made the decisions that I've made. Well, for the first question, it provides an exception. Logically, contextually, that's how it appears to me, and I hope the way that I've argued it in the Google Docs document, you'll see that as well. The second text that I asked you to look at can mean all of those 3 things, provided that in that case can mean if, except when, and. And as a result of that, the meaning changes 3 different ways, which means that from the reader's point of view, this might have a completely different legal effect to the one that you intended as an author. And of course, it's that ambiguity that we want to avoid in our legal writing, because if you mean one thing, then you have to communicate that meaning, and you have to be sure, or as sure as it's possible to be, that the reader will understand what it is that you want to communicate. And that basically sums up the last 3 weeks. We've got 3 terms which are known to the written legal English, plain English community, if I can say that, as meaning many different things. They are inherently ambiguous. Why? It's not because we've decided that those terms mean many different things. It's because the courts have decided that those terms mean many different things. So if the courts hate dealing with them and they criticize the use of those terms, then why are you using them? Why do people use them in their legal writing? The terms are ambiguous. Don't use them, full stop. There are much more precise alternatives which communicate your message and which should be used instead. Okay, that's it from me as regards the terms that you should never use in your legal writing. In the next couple of weeks, we'll have a look at some more things that you should watch out for in your legal writing because they can confuse the reader. But these 3 things, shall, and or, and provided that, make sure you never use them in your legal writing. If you've got any questions about those terms, then please get in contact with me. I'm more than happy to have that discussion with you, either through YouTube or Facebook, or send me an email. And remember, if you want to brush up your legal writing skills or your business writing skills, then head on over to my website at writtenlegalenglish.com, sign up for my course where you've got 17 units that puts you through your writing paces.